Welcome everyone to today's webinar. Today I have the pleasure of having Paula Mara from Rosenbaum with me here today. We're going to wait just about a minute or two so we can allow the participants to log in. And once we see the participant number get to a steady place, we'll go ahead and get started and do some formal introductions. But again, thank you for being here today. We look forward to providing you as much information as we can. All right, I think the numbers have stabilized. So I'll go ahead and introduce myself, and then I'll give Paula the opportunity to introduce herself and her and the firm. My name is Rafael Aquino. I am the CEO and co-founder of Affinity Management Services. We are a community association management company. We service Dade, Broward, and Palm Beach County. Our core focus is really providing our board members and our managers with education in order to make their lives a little bit easier and simpler to manage the community associations that they serve. So with further ado, I want to introduce Paula Mara. If you can kind of give a high level of view in the firm, and we can get started.
Good morning, everyone. Thank you for attending, and thank you, Rafael, for having us to discuss emotional support animals and service animals today. I have practiced in the state of Florida since 2003, primarily condominium, homeowners association, a lot of country club work as well, some litigation. Also was at a large firm for 14 years in Boca Raton, representing all HOAs, condos, clubs. I have with me, over to the side of me, who I think will be maybe filtering some questions, it's Katie Phillips. She was a regional property manager. She was a property manager for 23 years. She is our marketing and education director here at the firm. My colleague, Steve Brayton, 26 years, almost 27 years experience, again, primarily focusing on community association law. And the firm also has, in our association group, Michael Casanova, who I think has 11 to 12 years, again, primary focus on association law. So that's kind of who we are here at Rosenbaum Law Firm. We like to describe ourselves as a deep bench of experienced attorneys with our primary focus on answering corporate general legal questions for our HOA clients, condo clients, co-ops, because we know you're still out there, and our country club clients. And also we do a full spectrum of services here in-house at the firm, from litigation to planning and zoning and all of the different land issues that you may face from time to time. Thanks, Rafael.
Excellent. Thank you so much, Paula. So why don't we get started? I'm sure we have a lot of questions. As Paula had mentioned, we do have a Q&A at the bottom. So if you have any questions, please feel free to put them in the Q&A section, and we'll do our best to get through them either through the webinar or once we get wrapped up with the initial questions that we have. So let's get started here. Paula, I wanted to ask a question so our listeners or our viewers can get an idea. So is a condo required to allow a resident to keep an emotional support animal, let's say a dog, and allow it in the common areas if that animal is considered dangerous?
Yeah, you know what, let me back up just a minute.
Sure.
To let everybody know kind of why we're here, because I want to put a little bit of a framework before we dive right into that question, because that's a great question. And I want our listeners to understand, our board members to understand, when we discuss emotional support animals, we are talking about a different category of animal, and we are not talking about service animals. So you'll see through when Rafael and I answer questions or guide this panel through today's topic, we are going to reference two different types of animals. We'll be referencing a service animal, which is treated completely different than emotional support animal. And our service animals, I always like to describe to my clients, our service animals, you will know them when you see them. And that is the animal that behaves completely different. It is the dog or some other type of animal that is doing an actual work that you can readily observe is working for that person's disability. So that's the service animals. So from the outset, I just want our board members to understand that service animals are treated completely different than emotional support animals. Today, we're focusing on emotional support animals, but please just make sure the takeaway point is, you know, there's a difference, because service animals are governed by the Americans with Disabilities Act. Whereas, because our housing providers, including our community associations, you are considered a housing provider under the Fair Housing Act. And so today, that's why we're here. Because you are a housing provider, the association needs to make sure that you do not step in the wrong direction of the Fair Housing Act. And so that includes emotional support animal accommodations. I know today we see more and more of them. I think 5 years ago, we'd see one every 2 or 3 months. Now, 2 or 3 of these issues come up for our clients, just specific to this law firm, about twice a week on average. And I know Raphael sees it more often because before it hits the law firm, Raphael's management companies are dealing with this, and managers are dealing with probably on a daily basis for their clients. But to your question, when we have received an accommodation request for an emotional support animal, we've moved through the process as an association and understand that we have to grant that accommodation under the Fair Housing Act. The next question sometimes becomes, the animal itself has exhibited dangerous propensities, or it's exhibited behavior that is not acceptable with respect to other people being concerned about their safety, and it's not behaving generally in a manner which wouldn't create somebody else in the association to feel unsafe or threatened by this animal. The direct answer to your question is, just because you have been granted an accommodation for your emotional support dog doesn't mean that your dog can behave in a manner that is a threat or poses a safety threat to other individuals on the association property. So if it lunges and charges at other dogs, if it has lunged at other residents, if it has nipped or done anything else that you can justify substantiates a dangerous propensity, then the person loses their right to have that dog on the property as their emotional support animal.
Excellent. And you know what, that's a great point. And we've dealt with one situation where we had that, and it's, proving it becomes a bit of a challenge as long as you have some videos. So for those managers and board members, remember, just because you make a statement, we're going to need to provide some information to the attorney, where we could provide evidence. If it's a written statement from someone that's stating that the dog has lunged at that individual, or a video where you can reference that situation occurred. I do have a great question here from Amy, and maybe it's pretty simple for us, right? But what is an ESA? We have Amy's asking, like, what is an ESA?
Yeah, so let me kind of take a couple steps back. An ESA is, it's not defined in the Fair Housing Act, right? But it's an emotional animal, it's emotional support animal. That's what ESA stands for. So I think we'll keep saying ESA as opposed to emotional support animal throughout the. An emotional support animal is an animal that provides an individual that has either a mental disability or a disability with some type of relief. I like to call it, it's almost like medicine, right? It provides some type of relief that alleviates or ameliorates the person's disability. And that disability that the person has and the letter that's required to be given must be associated with the person's inability to perform a major life function. So I'm going to use myself as an example. I don't have an ESA, but if I ever had to have one, this is what the letters look like. The letters indicate that I have a disability under the mental health guidebook. It's a nice, big, huge book. It's about 10 inches thick. The medical provider who's providing the letter does not have to say what that disability is, but have to say that that disability affects Paula's ability to sleep or work or socialize. Again, a major life function that I am unable to do because of this disability. And then the next nexus that you have to meet to be defined as an emotional support animal is the nexus between my Boston Terrier, Bob, provides me a level of comfort and security, reducing my anxiety, and therefore I can function in social settings. And therefore I am entitled to have Bob as my emotional support animal. So it's almost like you're connecting the dots with respect to the entitlement to an emotional support animal when you do receive the additional documentation. So again, an ESA is an animal that is resolving someone who has a mental disability to the degree that they are then able to function with major life activities.
Okay, and that'll help me segue into my next question. So, what ways does an association have if they have, like, what alternatives if an ESA is already living in the building without documentation? What are some of the alternatives?
So if what's important also to note, which is, again, I'm going to distinguish between a service animal and an ESA throughout this. It's important to note that a service animal is allowed on the property without requesting an accommodation. And I always, again, like to say, you'll know it when you see it. I've never had a client call me and say, I'm questioning it's an service animal. They have questioned whether someone's holding their ESA out as a service animal. But a service animal, you'll know it when you see it, right? Mm-hmm. When you see it in the grocery store, you know, you see it at the airport, et cetera. So they do not, and you should not require a service animal to request an accommodation to your no pet restriction. You do need to require, and you have the ability to require the ESA animal to request an accommodation. So if you have an owner who has brought an ESA onto your property without properly requesting an accommodation from your pet restriction, then you can ask that owner to move through the process to provide documentation that they are entitled to an emotional support animal. And so that would be the next step. If you have an ESA on the property or a claimed, I'll call it a claimed ESA because it's not an ESA yet until the association has requested the accommodation after receiving the supplemental documentation to show or prove that it is a proper ESA.
Great. And you're right, you know, things have gotten worse. And I think things started to get worse once, you know, this became a business for some people where you could go online and for $25 or $35, whatever it may be, and be able to apply for an emotional support license. Fortunately enough, there were some things that changed in the statute that provided a little bit more protection for associations. So with that said, how can an association know, let's say they're applying for that emotional support animal, what kind of documentation should management or should the board request from that individual? And how can they prove that it's actually not, you know, some random shrink or some random person, you know, signing off on this document? What do you recommend board members and associations to do?
So prior to July 1st in Florida, and kind of let's hit upon that. Last year, legislation was passed and signed into law effective July 1st, where Florida actually defined an emotional support animal in various statutes across our statutory code. And in doing so, it also set out guidelines with respect to who is a medical provider and what type of medical service or interaction needs to take place before that medical provider can issue an ESA letter. I sometimes will call it like a prescription letter.
Yeah.
So with that, it did strengthen the ability of the association to question, in a sense, whether or not somebody was online. There's actually a provider somewhere near Ocala, I won't be specific, that would issue letters over and over again without having personal knowledge of the person's medical disability. So Florida law last year provided at least additional framework to say that the association can question whether or not that provider has personal knowledge of this individual's medical disability and therefore is entitled to issue such a letter. But that also includes the ability of the person to have a visit with their medical provider over the internet. So it did cut down on some of the providers that were issuing these for $50, send in your name and number. We do also still see, because people are uninformed, where if you Google emotional support animal, the first 10 hits you'll get under Google are apply for your emotional support certificate here, or your card, or your little orange vest for your pug, right? Mm-hmm. That's an emotional support animal. So those types of documentation and information can be questioned by the association. At the point in time the association moves forward to question or deny or request additional information, it is my strong advice, and I think Rafael will tell you this as well, is to reach out to your legal counsel. Definitely say, we don't want to make this your billable project of the month, so please don't handle it that way, Because if you have legal counsel that's practicing in this area, for most of its focus, we have the ability to look at these letters quite quickly, determine where they're deficient, and then send out a secondary letter to that person indicating it's deficient for the following reasons. It may be deficient because you did not meet the statutory requirements of a medical provider providing personal knowledge of your disability or for other reasons. So I do strongly recommend, and we'll touch upon this as well a couple times, I do strongly recommend that when you have those questions, consult your counsel, because if you move in the wrong direction or step in the wrong direction, then there's some real consequences to that.
Sure, and I couldn't agree with that even more, Paula. I mean, we get put into many circumstances and many different situations, and many times we get it, right? These are nonprofit associations. They don't have excess cash flow. But at the end of the day, you need to be making with the right business decision for your community, and it's your fiduciary responsibility to do so. So sometimes having to spend a couple $100s is much cheaper than having to, come out your deductible, contact your insurance company, and have to deal with a potential lawsuit. Further, it's going to provide you that opinion that you could save. So for those managers, you could save the opinion. Doesn't mean that every opinion is going to be identical, but at least you have a bearing now for your particular association. And then you could just chime with your attorney. And as Paula mentioned, if you're working with someone that's specific to the industry, they're going to be able to address these issues fairly quickly, give you a response in time so that you could get back to that individual with the proper response. Having a legal opinion, providing that to, if it's a denial letter or a request letter, it's going to come with much more teeth than, let's say, from the manager. I have a question here, Paula, from a lady named Carmen, and she's asking what other identification can be requested from an ESA.
So also, instead of receiving the letter from the medical provider, the individual can submit different government documentation indicating that the person has a disability from a few different governmental agencies, whether it's the Veterans Administration or your Social Security Administration, indicating that person's receiving benefits. So there's a few other documents that we can request if we're not receiving that medical, again, I call it a prescription letter. But outside of those that are listed in the statute, you shouldn't be asking for additional information. It kind of leads me into the next kind of thought that I have, though, when individuals that submit false information or those cards, those are not sufficient. So understand that the things, those documents that you receive that look like they've been received from an internet or the emotional support, the American Emotional Support Animal Association, you'll know by the title of them that those are not sufficient. So if it's not from a licensed medical provider, or it's not from a governmental type of agency that would show you that the person has a disability, and those are the types of documents that need to be questioned and returned to the owner to say, this is not something that substantiates the need for an accommodation to the no pet or weight restrictions or limited pet restrictions that we have.
Okay, so let me give you like an example of what we've seen. So let's say you get a doctor's note and the doctor's note says, the animal helps with the day-to-day activities. If you see that on a written statement, is that sufficient, or what's the verbiage that your firm would say is acceptable?
So the first thing that we're going to look for is the medical provider indicating that the requester has a medical disability or a mental disability or an emotional disability. And then the next thing we're going to look for is, again, whether or not that disability affects that person's ability to perform major life functions. Now, I will tell you that HUD, which is Housing Urban Development, is the agency that governs and controls the Fair Housing Act. So HUD has on its website a sample letter. And the sample letter actually, I feel like it was a little watered down a few years ago, because instead of citing a major life activity that is affected by the person's disability, it has in parentheses like anxiety and some other things that in today's world, I think we all have that, right?
Yeah, after COVID.
If you don't, I want to know you and know what you're doing.
We all needed a pet after COVID.
Right. Yeah. So if you don't have anxiety, then something's wrong with you, right? Not with.
Yeah.
So, but kind of back to that point, you want to make sure that that letter hits those points, and then it's going to indicate how that particular pet, and let's keep this in mind, everybody, as well. It's a particular pet. It's not just a random dog. It's a pet. It's by name. or by description, and that is the pet that the person's entitled to have once they meet all of those factors for your emotional support letter. But again, if you're questioning whether somebody has hit those factors, the next best thing is to consult your attorney. And the next thing that we do is we look at it, we send out that second letter, which says, you have described the following. We're very specific. You've described the following 3 things, but you have failed to provide the nexus between what Bob does for you to alleviate that particular symptom, which is caused by your medical disability or your disability.
Okay, excellent. So let's say that that person gets the ESA, accepted the association, and they have their ESA. Does the association have the ability, let's say within a year or 2 years or any time frame, to request that information be provided again? And then are there any restrictions with regards to the weight or the breed of the animal?
So yeah, let's take that in 2 parts, because the first question is a very good question. And it's a good question because prior to Florida passing the legislation that it passed, we even in practice would put at the bottom of our acceptance letters indication that we may or may not require you to reprove your existence of a continuing disability to enable you to continue to have your emotional support pet. The Florida statute that was passed specifically indicates that it's not proper to just from a blanket standpoint, request someone to continue to prove their continuing allowance for an emotional support animal. So associations want to be cautious when they accept the ASA and then put a requirement on that in a year you need to submit additional documentation for your continuing need. And also associations need to be very cautious. And I told Katie, maybe the name of this panel should have been, please don't. Please don't use an application to require someone to request an emotional support animal. It is specifically prohibited, and it will land you in the, it'll land you with the attorneys that today, instead of presenting this panel, they're out there looking for associations basically to bring in front of either your Office of Equal Opportunity here in Palm Beach County, the Human Rights Commission in Miami-Dade. I can't remember off the top of my head what it is in Broward or the other counties, but each county is going to have an office that a complainant can go to if the association has offended the Fair Housing Act. And one of the things that you can automatically do to offend that act and offend the Florida statute is require someone to fill out an application to request an emotional support animal. So if you take anything away today, it's that. I do have clients that still want to use something, by way of a document to walk themselves through what they need to do. And I don't have a problem with that, but in bold letters, this is an internal office document, internal processing document, not to be used as an application. Big bold letters at the top so that everybody from your administrator at the top of the, at the front desk who's going to be corresponding and talking to this person all the way down to a board member who may not know better. So no applications for ESAs, please.
Correct. Yeah, I couldn't stress that more. We get pushed in certain instances that no, we want to have an application. What I recommend for those board members and managers that are on the call is, as Paula said, have some kind of internal policy or standard operating procedure. Work with your attorney on that so that you're making sure that whatever you're saying or doing falls within, the legal realm that you need to be within. Because nowadays you can be included into any lawsuit, and in these lawsuits they are very serious because you're dealing with large entities. I have a question here from Andres, and he says ESAs has to be accepted even if it becomes a nuisance, which I believe you kind of addressed that in your previous comment.
Well, yeah. So in addition to the ESA being a dangerous animal or being a threat to others, it cannot be a nuisance animal, which includes even being potty trained. The animal can't go into the condominium building and make its business on the floor. It's absolutely a reason that you can deny the continuing need for that ESA based upon that. Or another type of nuisance that would come up very often is the barking.
Yeah.
Or not following other different rules of the association that are reasonable rules and don't frustrate the person's purpose to enjoy their unit. So absolutely, the association does have the ability to, if that particular ESA becomes a nuisance, to then retract that emotional support animal accommodation for that particular animal.
Yeah, and from my experience, Paula, I don't know about yours, but from my experience, where I see we have the biggest issue is in the no pet communities. I mean, you still have it throughout other communities, but I've seen that we have it over more predominantly, right, in the no pet communities. And you know, there's options. Some board members don't like to hear it. I tell them, listen, then this may be an opportunity to amend your document if it's something you're willing to consider. So, you know, there's different options. What would be your recommendation? Because from our perspective, we do see that they're the impacted the most. What would be your perspective on that? Or where do you see the impact the most in your communities?
Well, it certainly makes sense, right? For a no pet restricted community, there's going to be zero tolerance.
Yeah.
Whereas your weight restricted or number of pets restriction, there's going to be a little bit more tolerance for animals. That's just, it goes to follow, right? Correct. So for no pet restricted communities, it's a level of frustration that I'll disclaim. I'm a huge pet fan, but I live in a single family home with a fenced backyard with all of my animals in that yard. Katie laughs at me every time. So for those listeners today where your frustration level is high, I still get it, because you're choosing to go into a no pet restricted. Mm-hmm. I even heard one client one time say, I had animals my whole life, but now I'm fearful of tripping over an animal because that would do me great harm. So I don't want to be around animals anymore. I thought, that makes a lot of sense. You got to look at it from everyone's perspective. With that said, unfortunately, when we're asked this question, whether it's with existing clients or even new client interviews, I don't have anything hopeful really to suggest for our no pet restricted communities. With the passage of the legislation last year, that really just, in my opinion, replicated and maybe added a little bit to the existing federal law with respect to approvals for requests for accommodations. The next best thing you can do is really consult with your attorney for general guidelines on restrictions to certain areas and what reasonable restrictions you can place on that pet owner and the pet for ingress, egress. I mean, I see this more with our condominiums, our lobbied condominiums, our high-rise condominiums. The frustration level is even higher because you're sharing common elements. You're sharing lobbies, you're sharing elevators, you're sharing different spaces with this particular pet and the owner. So it's a little bit different. My suggestion would be to definitely consult with legal counsel, because one of the other please don't would be this. Please don't put blanket restrictions across the board on your ESA animals. For example, if you have a 93-year-old ESA person and she has a Labrador who's 45 pounds, it would not be reasonable to expect her to pick that Labrador up and put it into a dog stroller each time she goes through ingress to egress to her unit, because she's 93, she's 5'2", and the dog is 45 pounds. So if you're in front of a federal judge and you're trying to determine whether or not your restriction was reasonable for that ESA, a federal judge is going to go, well, of course that affects her enjoyment to her unit, because every time she leaves, she has to stress out as to whether or not she can get this dog in the stroller. Compare that to my example where you have Raphael and he has Toto, his 8-pound Chihuahua. And we've asked Raphael to put that Chihuahua into the dog stroller to walk the Chihuahua to and from his unit, because that's reasonable. And it's also reasonable because we're meeting the needs of our other no pet owners with respect to that. It may be reasonable to provide that the person uses the service elevator to walk the dog in and out. And that may be reasonable if the service elevator isn't located 200 feet from the actual elevators. So all of these different factors come into play on what pet restrictions you can make for individual ESAs. But I do want to stress it's on an individual basis, and you should consult legal counsel to determine what limitations you will place to meet the needs and balance those needs of both the no pet owners and your ESA owners.
And have you experienced where, let's say, a husband and wife and each of them ask for an ESA, and what are the procedures there?
So an ESA is not a pet. So an ESA, like I said, it's like a prescription.
Yeah.
And you're not going to deny one because you already have the other. And I hate to tell you as well, and I laugh, I don't know why, like I think sometimes I laugh because it can be a little frustrating, again, for a lot of parties involved where you're balancing the rights of each. And that is whether or not you can have two ESAs, because either one of the ESAs does something for you, again, by way of your letter received to document that, Bob does this for me, and therefore I can perform a major life function because he ameliorates that disability. And then Bentley, the other Boston Terrier, performs this function for me. So now I'm walking into your no pet condo with Bob and Bentley, which is never a good scene.
Of course.
Yeah. So my point is, yes, you can have two emotional support animals as well. And that was codified in the Florida statute where it wasn't in federal law. So that's something that changed where it references that. I don't know if it was the most helpful change, because before we were kind of wandering around federal law determining whether or not is a person entitled to two ESAs.
Correct. And now another question, which Katie gave an excellent name to this webinar, which is, can I take my peacock to the pool? Are there any animal restrictions on the type of ESAs that owners can have?
There are going to be animal restrictions. I'll take, for example, for a service animal, you can have certain types of wild animals, even like a monkey, that can perform service animal functions for the owner. An ESA, again, you're going to draw back to the fact that that animal has to, it's not going to be an animal like a peacock. We're not going to have peacocks in even a single family home. We're not going to have peacocks in our condos. We're going to have the domesticated types of animals that would be appropriate for your ESA.
Okay. And what happens if let's say they lie? Let's say that it's a dog, but what they're bringing in is a cat.
Well, that's going to go back to the letter is then insufficient, because your letter or your documentation is going to be specific to that particular animal, the name of the animal, the breed, so that you can document it's the same animal. If that animal passes, then that would be one of those, in my opinion, that you need to then go back and make sure you get the prescription letter for your new animal to substantiate the need for that new animal.
Okay, excellent. I have a question here from Amy online, and she asked, our docs only allow one dog under 30 pounds per unit. Can the ESA be any animal, and which that one we already addressed, an over 30-pound limit?
So the answer is yes. The dog can be 120 pounds. It can be a bull mastiff. It can be a pit bull. It can be a Rottweiler. This is based upon a case. I think the case is about 10 years old. It's in Miami, where even Miami code pit bulls, but under federal law, it was determined that the pit bull was an emotional support animal and therefore was allowable. So that's kind of how we use and interpret that decision. So even though you have a pet restriction of 30 pounds, if somebody has an emotional support animal that is over that, then you look at that nexus between the animal itself. You can't restrict it to your pet restriction, because again, it's an animal, it's not a pet. So that pet restriction would be the accommodation for the size as well.
Excellent. And James has a great question here. So he says, with regards to vaccination, can the association have vaccination requirements?
That's a great question. So one of the things that we can require is to confirm that the ESA has met the vaccination requirements in any other county code with respect to your pet that's required to be, inoculations and things like that. So you can ask them for the vaccine records, and you can then, because rabies, I believe it's annual, you can ask for the updated information from time to time to make sure that the dog has been vaccinated for rabies or whatever else is required.
Okay. I have another great question here is, let's say if they want to have the ESA have a tag on so that it's registered already with the association, is that permitted?
That's the first I've heard of that. I would think that would be permitted because it's reasonable. It's not interfering with the person's use of enjoyment of their unit. So I think that would be a reasonable request that the association make in conjunction with the approval of the accommodation.
Correct. And in our community, from a management perspective, we had an association that actually wanted to designate different colors for ESA and non-ESA animals. That, it was recommended to just keep it the same. So we did require everyone to go through the process of, okay, we need to provide the vaccination records. We gave everyone, I think in that association, it was blue with a number. And then that way they knew that each pet was registered, whether it be an ESA or whether it be just a regular pet that was permitted within the community. That allowed the association to know if there was a pet roaming around the community without that registration, that we can reach out to that owner and ask, hey, this pet is not registered, and not making sure that we're not asking the wrong question, but this pet's not registered within the community, and let them know what steps they need to take in order to get the pet registered.
Right, so that's a good point, Raphael, because you want to keep it equal across the board.
Correct.
ESAs and non-ESAs. You don't want to point out that it's the ESA.
Correct.
Designation. So that's a good point. I'm glad you kind of clarified and brought that up.
Yeah, correct. Because imagine then technically someone can argue that you're giving out their medical conditions, right? I mean, today we can sue for anything. So I could see something like that coming up.
Yeah, that's a great point. And to that point as well, when you're a board member and you're asked, because you know that this is your frustration level as well, because you're going to be asked, why does this person have a dog? Why does this person have a cat? The best answer is this person requested an accommodation under federal law and Florida law and was granted that accommodation, period.
Yeah. Yeah. And I want to stress the importance of working with your partners. As I stated earlier, everyone comes up with great ideas, but ultimately we need to be careful with some of the ideas that we can come up with, because they can create major impacts and an expense to the association. So that's why, again, I want to stress, not just because Paula's here, but just the way we do business is you want to make sure that you're dealing with your partners. And we rely heavily on our attorneys, our landscapers, elevator companies. We have to rely heavily on them because they're the professionals. They're the ones that deal with the day-to-day. They're the ones that are in the courts and know what other cases that they're doing. They're doing studies on cases to defend other associations. So they have the whereabouts and the knowledge to be able to answer your questions and just bounce that idea off them. No different than if you own your own business. They say you should always have a strong accountant, an attorney, and a banker. No difference than in managing an association. You're technically managing a business, so it should be conducted the same exact way. I have a question here from Tony. Can our association also require insurance related items for that ESA in case an injury occurs?
No, you can't. So unless you had, even if you had a no or pet restricted rule, again, it's not a pet. So even if you had that rule for all of the pets in your community or some type of additional rule, it would probably be more like a hold harmless or an indemnification. So the answer is no, you really can't. I don't think that'd be reasonable for you to require that. In fact, I know it wouldn't be. And also keep in mind, everybody, you can't charge your pet deposit. Yeah. So if you do have the limitation on just weight or number of pets and you have a pet deposit, that would not apply to an ESA.
Yeah, thank you for bringing that up, because I've had several clients ask us for that. And yeah, that's an immediate no, you can't be requesting anything. So we mentioned earlier, Paula, with regards to that letter from a doctor to determine whether it's an ESA, it's needed for that person. Can you give our audience a little bit of an explanation of what's permitted? Can it be someone from Canada? Can it be a televisit? Maybe go into a little bit of detail of who can prescribe that for the resident.
Right. So it does have to be a licensed medical provider. And again, Florida statute codified what that license means. And when you're talking about televisits, yes, it can be a televisit, but that medical provider, just by virtue of performing a televisit, has to still have the personal knowledge of that person's health or their disability. It can be in a different location, but with that, it has to meet certain other statutory requirements if it's out of state. But ultimately, again, licensed medical provider, that's a pretty broad brush stroke, if you will, with respect to how they codified that in Florida. It can't be someone, again, and you have this from time to time, it can't be those internet providers where they're just sending a certificate and you're sending them $50. So outside of that category, typically we don't see any issues with the medical provider, even if we know that unfortunately she's got 50 people in Palm Beach County that she sees over the internet from wherever she is in North Florida. So long as she or he is putting in the letter that they have the personal knowledge and is treating this person, then that meets that requirement. Now, if somebody misrepresents, and this was again codified last year, if we have a feeling that someone has misrepresented or has not been truthful in issuing that letter, there is the process that you can file a complaint against that person. But I don't know any association that would probably go in that direction, because I think it'd have to be pretty egregious for me to say, okay, I think we should spend the association's funds to fight this otherwise proper ESA letter by taking the claim that we know that it was not issued in good faith or is not accurate or misrepresents the person's condition. Unless you had a pretty serious set of facts to do that, it's not something I would recommend. Whereas if you do who's holding an animal out as a support service animal, that's a whole different piece of legal advice that I would give, because now that is a misdemeanor in Florida, and you can refer that. And if someone's holding those service animal cards out or has a service animal vest, that is something that the association may want to approach, as that person is committing, fraud by holding that service animal out as an ADA service animal when it is not.
Correct. No, it's sad what this whole ESA situation has done to individuals with actual service animals. I mean,
Yeah.
There's a major difference between a service animal and an emotional support animal. I mean, and I've never seen a service animal, do anything that you don't even know that the animal's there 99% of the times. They're very well behaved. They're very quiet. They do what they need to do. And it's a shame how people have, just been selfish in their own ways just to resolve whatever issues. And again, I'm not saying that people don't need emotional support animals. What I'm saying is that because of the abuse of some individuals, it's made a major impact to individuals who actually have a service animal, and it's sad. It's very sad. I have a question here now. We'll go through some of the Q&As, Paula. I have a question here from Vicky. And she says that basically there are no pet community, but she would like to know if they can put in their documents specific rules for ESAs.
That's a great question, and I'm glad it was asked, because my advice on that when I'm doing document amendments, I have my clients always say, well, we want to put in something about the emotional support animals and requesting an emotional support animal. And the manner in which this process, an amendment process for your governing documents should be is, your governing documents are your restrictions, your covenants, and that's the way it should stay. You should not, in my opinion, include any information about a request for accommodation process for an ESA. If you have a no pet community, then your governing documents indicate it's a no pet community, period. If you have weight restrictions or limitations on number, that is what your governing documents provide. And then again, you may receive from legal counsel a policy or board member's handbook, step-by-step, when you receive a request for accommodation, whether it's for an ESA, but keep in mind, everybody, you could receive a request for an accommodation for a swinging bench located outside of someone's patio on your condominium property, which is determined to be a common element. So a request for an accommodation under the Fair Housing Act is not just for ESAs. It can be for a myriad of things where the person is requesting an accommodation to your no pet restriction, or no patio benches on the patios, or a lot of different things. I can't think off the top of my head, Raphael. You could probably come up with a couple examples where, a parking spot movement is a good one for our condo. Yeah. I slipped and fell last year. Now I have, bad hips and I can't walk the 10 spots that I used to walk. So I'm requesting my parking spot to be changed. That too is a request for an accommodation. So takeaway point is no, I don't believe you should include anything in your governing documents with respect to Fair Housing Act and your request for accommodation under Florida law. It should be what your restriction is, and that's it.
Correct. Yeah, I would agree, because technically then what you're doing, you're putting the actual application process out there. So that should be more of your back office kind of ordeal. I have a question here from Helen. Can an ESA be allowed in the pool area?
It depends. My general answer is I think it's a reasonable restriction to restrict the pet from the pool deck and especially the pool. The pool is no question. The pool, that's an issue of health. So that is a no-go. So that would be something that I'm not going to question. But from time to time, depending upon the facts, depending upon what the person is claiming, it may be unreasonable to restrict that animal from the pool. But I do think that you should move through the deliberative process to determine whether or not that is a reasonable restriction to put on the ESA.
Excellent. I have a question here from Faye that I'll go ahead and address. The question is basically, again, about an application or forms to track that animal. And I think Paula has mentioned multiple times that the application, we shouldn't be doing that. With regards to tracking from a management perspective, we could take that information down. We can keep it on the back office side where we know that that pet is an ESA. We can put a label as stated, or a dog collar is what we call it, letting them know, again, keeping uniformity against throughout the entire community. Mm-hmm. So that's how I would say we would track it. Same thing goes if they have vaccination, depending on the systems that you have. We have a system where we can track that information from the back end. Not necessarily that we're going to make that public to the residents, but at least we have that information. So I hope that answered your question. Let me see what other questions we have here on the Q&A that maybe we have not addressed. 1 second, let me see. Okay, we have here from Bud. Bud says, we only have one dog per condo unit. This has been a rule for 40 years. Basically, are we saying that that we have to allow 2 dogs in one unit if both are valid ESAs?
So if you have a 1 pet restriction or a 2 pet restriction, then the 2 animals that are not emotional support animals, those are the pets. So you'll have 1 or 2. We'll use the example of 1. We have 1 pet named Bentley. And then we'll have Bob, who I've already told you is my emotional support animal. So now I have Bob and Bentley. And I'm not, the accommodation was for the second animal, which was granted because it's not considered a pet. It's an emotional support animal. So to your question is, yes, the person can have then 2 in the unit, 1 being the documented emotional support animal and potentially the second being just the pet.
Yeah, and that's what we commonly see in those ESA requests in pet communities, permitted pet communities, mm-hmm. where a family has 2 dogs and they want to move in, and they'll have 1 registered the normal way, and they'll just get a simple certificate or do whatever they have to do, get whatever doctor they need, and that's how they're getting. So that's where we see the abuse in regular associations. It's when they're trying to get a pet that's a little bit over the weight or get an additional animal into the community. Again, that's not everyone. But there are some instances where you know that the abuse does exist.
Right. And I'm glad you brought that point up, Raphael, because sometimes it's obvious the person went out and got the letter because they realized, because their realtor failed to tell them, mm-hmm. it's a 1 pet community. And lo and behold, in the application, they list their 2 pets and we're told, I'm sorry, we're only 1 pet. And then the letter comes with the date of, the day after they were told, for the emotional support animal. So we have an example occurring right now with that very example. We gave the pros and cons on contesting that emotional support animal letter based upon those particular facts and are moving forward to disapprove that accommodation request. I think in the next couple of years, you're going to see some type of case law or guidance from HUD, hopefully, with respect to when it's clear and obvious that the emotional support animal hasn't been an emotional support animal for 2 or 3 years, that it's just now become one because they realized upon their application process to purchase or lease the property that there was a restriction there. So I'm going to see what's going to go on with those types of cases, because I think that, again, it's an area of trepidation with respect to disapproving when they have checked all the boxes on that letter or other documentation to show it's an ESA. But there are going to be some fact patterns that will show up over the next couple of years that hopefully will give us more guidance on when it's clear and obvious that the person just went out and purchased or, met with the medical provider to obtain that letter, that it may be, false documentation or misrepresentation of the need for an emotional support animal.
Excellent. I have a question here from Fernando. So is it possible to make an individual annual charge, let's say example, $50 by concept of registration fee for ESA? Yeah.
So any type of pet deposit or registration fee, even to confirm a request for accommodation will land the association straight into a complaint with HUD. And let's also keep in mind, it's a good time just to remind or introduce the fact that if I have applied to your association, and again, I'm going to come in with Bob and Bentley, my 2 emotional support animals, because I have documentation for both. And the association is requiring me to submit a pet deposit and has denied my request because I refused to submit a pet deposit. What I'm going to do is I don't need to hire an attorney. I just have to go down to the Office of Equal Opportunity in Palm Beach County and file a complaint form. And then I'm given a caseworker, and the caseworker opens the case against the association and moves through the fact pattern, takes investigative information from both me and the association board of directors, or from Raphael at the management company, and determines whether a violation under HUD has taken place. Oftentimes there will be an opportunity for a reconcilable meeting between the 2 parties to see if it can be resolved. And if it's not, what can occur is the association can be fined or charged with the fees that the Office of Equal Opportunity has incurred, like a penalty fee. And I've seen several times before where those board members that were serving on the board at the time that they denied that request improperly, then have, you know, a certain number of hours, 10 to 15 number of hours that you have to take certain counseling courses. So I think, again, the takeaway point is I don't need to go shell out a retainer for an attorney to take my case. I can go to the county, for whatever county it is, and file a complaint with the Fair Housing Agency, and HUD will move forward with that. And if it gets worse, or if it's very egregious, HUD could also sue the association in federal court for the violation of the Fair Housing Act. I have not really seen that often, but it does happen and can happen.
Yeah. Yeah. So from a management side, that's one of the things that bothers the board that does the registration, is that they don't charge for that tag. Any other regular pet, there is a $50 registration fee or whatever it may be. In that case, you know, the board was advised you can't accept security deposits. You can't charge them for that tag. Ultimately, what you're looking to do is just to make sure you have uniformity and that they're being registered. So in those instances, you have to eat the cost. The cost of doing business is the way I tell the board, and it's what we're dealing with today. So Marlene, I believe you had a similar question with regards to maybe changing out the tags every year to make sure there isn't any forgery amongst the pets. That's a business decision, again, that you'd have to make if it's a policy of association that you issue new tags, the same way you may decide to issue new decals. Some associations do that. However, you have to factor in that if you're trying to control the ESA portion of it, you are going to be eating the cost of those new tags for all the ESAs that you already have registered, because you won't be able to charge those individuals for the reissuing of those tags. So just keep that in mind. It's a good approach, but it's more of a business decision at this point, if that is depending on the expense for you and your community. I have a question here from Umberto. Can a chiropractor or a podiatrist prescribe an ESA? I'm not going to put he said, or service animal, but we know service animals are totally different.
Right. Without looking and referring back to the statute right now, my answer is going to be yes. It's a medical provider, and that's a very broad brush of what a medical provider is.
Okay. Excellent. I have a question here from James. It says, can we take a picture of the animal for the association's files?
Yeah, I think that's reasonable. I don't think that that's restrictive. It's not requiring them to pay any amount of money or anything like that. So for your own association files, and keep in mind, I think, Raphael, you touched upon this, those are official records of the association, but those official records relating to the health or medical information are not inspectable. So you'll want to make sure that you organize your official records to confirm that you're not disclosing that information in an official records inspection for an owner. Correct.
And yes, I'll tell you from a management perspective, that's a good way to answer Marlene's question instead of maybe re-registering every year, is taking a picture of the pet. Now you have to ask yourself the question, Do you have the team members to be able to follow through on these policies? Because ultimately the policies are only as good as the follow through, the execution of those. So if you have just one manager on site, you know, I don't know if if it makes financial sense to have your manager inspecting every single pet as they walk through the community. So these are the factors that you need to keep in mind. Again, working with a strong partner, they're going to give you these opinions or these suggestions, I should say, on what's the right approach, because it makes no sense to put together a rule if you can't enforce that rule.
Right.
I have a question here from Andreas, which I believe we may have answered, but some people try to register more than one dog as an ESA. Is that appropriate?
It may be when, again, both dogs have met the requirements of having separate letters or one letter, which separates the need out for both dogs from that medical provider.
Excellent. We're getting some really good questions here. If Carmen asked if an association has a DNA program in place to identify LSA violations from waste of the animal, can the ESA and service animal be included within that?
I would not include the service animal in that because, again, like you mentioned earlier, you're going to know a service animal because they don't even act like animals. You don't pet them. Nobody wants their service animal to be approached. And I think it would just offend the ADA to some degree to require that additional requirement. There'd be no purpose in doing so anyway, because you're never going to have a service animal. Typically, I shouldn't say never. It'd be very rare for a service animal to create a danger, pose a threat, or defecate and not and be in violation of some other rule with respect to that. But as to the emotional support animals, yes. But again, you wouldn't be charging for that DNA test. So that association would be required for the cost of that DNA profile test.
Okay. I have a question here from an anonymous that says, we requested the documents showing that it was an ESA, but the resident said the doctor is requesting a letter from the association justifying why we are requesting that. Do we need to provide this letter?
You don't need to provide that letter, but it may be a common sense approach. So legally, no, you have the ability, the association, to request the documentation. And it's not required that you provide any type of form or, formatted type of request so that the person can submit it to their doctor. With that said, sometimes when we receive inadequate information or a refusal to provide information for whatever reason, that's when we have a standard letter which says, we understand that you are reluctant to provide information, but according to Florida statute, Fair Housing Act, these are the types of documents that we will receive or can receive so that we can move through the deliberative process to approve or deny your request for accommodation. Please note that this letter is not denying your request for accommodation at this time, but we are requesting the requisite information.
Okay. And you know what, Andres again pose a good question here. And we've been talking a lot about the ESA side of it, but let's say we get someone with an actual service animal that comes in. What documentation would you say is appropriate to request in that instance?
So the standard we're going to use for a service animal is if it is readily apparent that service animal is doing work or performing function. And when I say readily apparent, it means with your own two eyeballs, you're looking at this and it's clear to you that it's a service animal. And I really don't see this issue come up for us at all, because again, I've said this like 4 or 5 times. You know when you see it when it's a service animal. And just because, again, you have your vest on your pug or your chihuahua doesn't make it a service animal, even though it's an orange service animal. And when you have something like that come up, you should consult your legal counsel, because that person is in violation of federal law and Florida law. But if you do anticipate that it's a service animal, again, you're going to know it when you see it. If you have some concern that someone's holding a service animal out and it's not a service animal, I would suggest consulting your legal counsel to see what you do next with respect to that. So the straight answer to that is you can't require any additional documentation so long as it's readily apparent that it's a service animal. And we just haven't, in my years of experience, I've never had that come up, because you know it when you see it, it's a service animal. And most of the time you and your own thought process is, it's a service animal. So you wouldn't be any additional documentation or requiring any additional documentation or restricting that service animal's access to any of the property.
Correct. I mean, there's some obvious situations where, let's say, where our team has seen it, where you see, you know, a blind person on a wheelchair and the dog is the one guiding them. So in those instances, you know, we're kind of trained that, you know, that we're not going to be able to provide that. We're not going to request that information. That's evident that that person has a disability and needs that pet in order to do what they need to do.
Right. And I think the takeaway words for that, for me, that's helpful to distinguish is the words readily apparent. It's readily apparent and obvious that it's a service animal. And forcing a readily apparent and obvious service animal to provide additional documentation, again, is actionable. So you want to avoid doing that and make sure that everyone understands that they're, again, from the moment that I first spoke, they are two very different animals.
Correct. Excellent. So I went through the questions. I think we've answered all the questions. Some of them that were still here, we've already gone through. So in respect to everyone's time and keeping it within the hour, is there any closing remarks that you have or suggestions that you have for our managers or board members that are attending today?
Yeah, I think that just a few takeaway points. And that first takeaway point that I'm seeing very frequently, which makes me cringe, is the applications. So please stop using applications. There are different methods that we can suggest to you with respect to the ability to provide like a guidelines. We do have clients that still want to have like an intake sheet. I'm okay with that so long as it's labeled at the very top. This is not an application. You do not need to fill this out. Please note this is not an application over and over again, but in an effort to receive information to consider your request, this is for convenience only so that we can process and make a deliberate decision for your request for accommodation. And the second takeaway point is a service animal is not an emotional support animal. So let's just all decide that we understand and can distinguish between those two. And then third, an emotional support animal is not a pet. So all those different pet requirements, whether it's deposits or different registrations, et cetera, may or may not apply to that emotional support animal. Your deposits and different charges and costs are absolutely prohibited for an emotional support animal. Restrictions on availability for that animal to go certain places, it's a case-by-case basis. I gave you the two examples between the elderly woman and Raphael, right, on where they can go in the common element lobbies, et cetera. So it's a case-by-case basis. So in addition to please don't have an application, please don't have a blanket statement about where the emotional support animals are allowed to go. And that includes, because this is a big one, that includes where the animal is allowed to defecate. So that also is going to be on a case-by-case basis. Federal case law on that as well, where it's unreasonable or it affects or interferes with the person's ability to use their unit. So it really needs to be on a case-by-case basis and understanding all the different nuances that are at the level of federal law with determining whether or not kind of the ground basis is, does it interfere with the person's enjoyment of their unit?
Okay, excellent, Paula. Well, if I can kindly ask everyone to pull out their phone. I know we've had a couple questions if the video is going to be available. Yes, we will have the video available on Affinity's YouTube page, so feel free to scan the QR code. I'll go ahead and provide my closing remarks while you do that. And make sure you subscribe to our channel. We do have weekly videos and webinars coming out on Tuesdays and on Thursdays. So kindly subscribe to our YouTube channel. Before closing, I wanted to thank Katie and her team and Paula for doing the webinar with you. Sorry, for doing the webinar with me. It's always a great pleasure to deal with the two of you and dealing with your firm. I know we believe strongly in partnering up with firms such as yourselves and teams such as yourselves so that we can get most of these answers that we need answered for our board members and for our associations. To our board members and our managers on the call, I personally wanted to thank you for being on the call. It says a lot about you, the knowledge that you're looking to gain to better serve your community and better serve your residents. So on behalf of Ashley from my team and Katie from Rosenbaum and Paula, I want to thank you all for being here today, and we look forward to doing another webinar together.
Thank you.
Thank you. And
Thank you. Have a good one.
for attending.
Thank you.
Thanks.